Welcome back to the deep dive. We're continuing our journey through the MPP, the Manual of Patent Examining Procedure.
Right. Think of this series as, well, breaking down this huge guide section by section, making it a bit more digestible.
Exactly. We're using the official USPTO guidelines as our source, really getting into the nuts and bolts for you.
And today, our focus is MPP Section 1859. It sits within Chapter 1800, which is all about the PCT, the Patent Cooperation Treaty.
Okay, so 1859, what's the core mission for today's deep dive?
We're going to unpack the procedures for when you, as an applicant, need to withdraw something from your international application. It could be the whole application, maybe just some countries, or even a priority claim you made earlier.
Based directly on the rules outlined in this section.
Precisely, straight from the MP, based on the PCT rules.
All right, let's get into it. MPP 1859. So fundamentally, this is about giving applicants a way to change course during the international phase.
That's a good way to put it. It's the procedural roadmap for hitting, maybe not reverse, but definitely adjust. And this authority comes specifically from PCT Rule 90 Bis.
Rule 90, boys.
Huh?
Okay, what does that rule allow applicants to do specifically?
Well, it gives you three main options. First, you can withdraw the entire international application. Maybe things change, plans shift.
Okay, scrap the whole thing internationally.
Right. Second, you can withdraw specific designations. So you keep the application going, but decide you no longer want to pursue protection in, say, Japan or Germany. You withdraw those specific designated states.
More targeted. And the third?
The third is withdrawing a priority claim. Maybe you realize an earlier filing date isn't helping, or you want to shift the effective date for strategic reasons.
So Rule 90 Bis provides these options, but I'm guessing timing is everything here.
Oh, absolutely critical. You can't just do this whenever you feel like it. There's a strict deadline.
Which is?
Any withdrawal of the application, designations, priority claims must happen before 30 months expire from the earliest priority date.
30 months from the earliest priority date? That's a familiar deadline in PCT land.
It is. It often marks the deadline for entering the national phase. So this withdrawal deadline lines up with that key moment. You need to act before that 30-month window closes.
Got it. So you decide to withdraw something before the deadline. Where do you actually send the paperwork, the notice?
Good question. It depends a bit on where the application is in the process. Sometimes you send it to the International Bureau, that's WIPO in Geneva.
The central PCT authority.
Right. Or you might send it to the receiving office. That's usually the patent office where you first filed the international application. So for U.S. applicants, often the USPTO.
Okay, WIPO or the Home Office. Are there other possibilities?
Yes, in some situations, especially if you've requested international preliminary examination, you might send it to the International Preliminary Examining Authority, the IPEA.
Huh.
The source mentions this can depend on the phase and if Article 39 of the PCT applies, which relates to that examination phase and potentially delaying national entry. The bottom line is you need to know who's handling the relevant part of your application at that time.
Makes sense. Send it to the right desk.
Hmm.
Now, let's talk effects. What actually happens when you withdraw something?
It depends entirely on what you withdraw. For instance, if you withdraw all the designated states...
Saying you don't want any of the countries you listed.
Exactly. If you do that, the PCT system treats it the same as withdrawing the entire international application. Functionally, it kills the application in the international phase.
Okay. Withdrawing all designations equals withdrawing the application. That's important.
Yeah.
What about withdrawing just a priority claim?
This is where it gets interesting, particularly with deadlines. Withdrawing a priority claim can change your effective earliest priority date, right?
Yeah, I can see that. If you withdraw the claim to your first provisional, maybe the international filing date becomes the earliest.
Precisely. And if that happens, if withdrawing the claim results in a later earliest priority date, then any PCT deadlines that haven't already expired get recalculated based on that new later date.
So open deadlines get pushed back.
Potentially, yes. But, and this is crucial, any deadlines that already expired based on the original earliest priority date, they stay expired.
No second chances on missed deadlines.
Nope. Withdrawing a priority claim can't turn back time for things you already missed. It only affects the clock moving forward for deadlines that were still active. It's a strategic point. It might buy you time for future actions, but not fix past omissions.
That's a really key distinction. So why would someone do this strategically? beyond just changing their mind.
Oh, definitely strategic uses. A big one is managing international publication. PCT applications usually publish around 18 months from the priority date.
Right, becomes public knowledge.
But if you withdraw the entire application before the International Bureau completes the technical preparations for that publication,
You can stop it from publishing.
exactly. You can keep the invention confidential, at least through the PCT system. Maybe the market changed, R&D shifted, or you opted for trade secret protection instead. Timely withdrawal prevents that automatic publication.
That's a powerful tool for confidentiality. What about withdrawing just designations?
That's more about refining your strategy. Maybe the initial commercial interest in a country didn't pan out or the costs are too high. Withdrawing specific designations cleans up the application and saves you hassle and potential costs in those specific national phases later. It focuses your efforts.
So it provides flexibility as things evolve.
That's the idea. Adaptability. But like we said, it's a formal process. You can't just, send a quick email.
Right. What does that formal process involve?
You need to submit a formal signed notice to the correct office and the signature part. That's where you really need to pay attention, especially if there's more than one applicant.
Ah, yes, the signing rules.
Yeah.
This can trip people up, can it?
It really can. The basic rule is if you have multiple applicants, like co-inventors who are all applicants, generally all of them need to sign the withdrawal notice.
Okay, all hands on deck, usually. Is there a way around that?
Yes, the main exception is if you have an authorized agent, think a patent attorney or agent, or a common representative who has been properly appointed by all the applicants.
Properly appointed being the key phrase there.
Absolutely critical. They need formal authorization, like a power of attorney, explicitly allowing them to act for everyone on matters like withdrawal. If they have that proper appointment, then that single agent or representative can sign on behalf of all applicants.
Okay, so formal appointment grants that power. What about the situation where someone is just the common representative by default, like the first person named on the application, but without a specific appointment document?
Great question, and the MPEP is clear on this. That default common representative, they do not have the authority to sign a withdrawal notice for the other applicants.
So just being listed first isn't enough.
Not for withdrawal, no. That default status doesn't grant the power to take away rights from the others. Only a properly appointed representative or agent has that specific authority when it comes to withdrawal. It's a safeguard.
That makes sense. Prevents one person from pulling the plug without everyone else's explicit okay, unless they've already formally agreed to let someone act for them.
Precisely. Get the signature wrong, and your withdrawal notice might be invalid.
We mentioned avoiding publication earlier. Can you just re-emphasize the timing on that? It sounds tight.
It is tight. To stop publication, that signed withdrawal notice has to physically arrive at the International Bureau before they finish the technical preparations for publishing the application. They start that prep work well before the 18-month publication date.
So you need to act fast if that's your goal.
Very fast. If it arrives after they've done the prep work, it's too late. The application will be published.
Okay. Are there other limits? What if, say, the German Patent Office has already started examining the application based on the PCT filing? Can you still withdraw the German designation via the PCT?
That's another important limitation. Once a national or regional office, like the German office in your example, has started processing or examining the application under specific PCT articles 23.2 or 42, then a subsequent withdrawal notice filed through the PCT system for that designation has no practical effect in that specific country.
So the PCT withdrawal can't stop a national process that's already underway.
Correct. Once the national phase work has formally begun in a particular country under those rules, the international withdrawal mechanism loses its power for that country. The application will likely continue being processed there according to their national laws. You'd have to deal directly with that national office then.
The authority kind of shifts to the national level at that point.
In essence, yes.
Is there a standard form for this?
Right.
And dare I ask, is there a fee?
WIPO does provide a helpful form, PCTA B372. Applicants can use it, makes things easier. It covers all the withdrawal types, application, designations, priority claims, even preliminary examination elections.
Okay, Form 372 and the fee.
Good news here. There is no fee charged by the International Bureau for filing a notice of withdrawal.
Wow, no fee. That's refreshing in patent law.
It certainly is.
All right, so you file the notice correctly, using the form or ensuring it's clear, signed properly, no fee needed. What happens next? Who finds out?
The International Bureau handles the notifications. This is covered in PCT Rule 415. First, they record the withdrawal and the date they received the notice. Then they let people know.
Who gets notified?
They notify the receiving office where you filed, the applicant themselves, a confirmation, essentially, and crucially, any designated offices that are affected by the withdrawal.
So if you withdrew the designation for Canada, the Canadian office gets notified.
Exactly. They need to know not to expect the application to enter the national phase there via the PCT route anymore.
What about the search or examination authorities, the ISA or IPEA?
The International Searching Authority, the ISA, gets notified too, but only under certain circumstances. Basically, if the withdrawal is for the whole application or a priority claim, and if the ISA hasn't finished its work yet, meaning the search report and written opinion haven't been issued. If the search is already done, notifying them isn't typically necessary for a withdrawal.
Okay. Any other notification wrinkles?
There's one specific scenario mentioned. If the withdrawal is for the entire application and you filed the notice with the receiving office before the receiving office sent the official record copy of the application file to the International Bureau.
So very early in the process.
Right. If that happens, the IB might not even have the main file yet. So the notification process is simpler. The IB just notifies the receiving office and the applicant. They don't need to notify all the designated offices because the application hadn't really fully entered the IB's main processing stream yet.
That makes practical sense. Keeps a loop smaller if the information hasn't spread widely yet.
Exactly. It shows how the procedure adapts to the application's precise status.
Okay, let's try to summarize this. MPE 1859, drawing from PCT Rule 90Bs, gives applicants ways to pull back or adjust during the international phase.
Right. You can withdraw the whole application, specific country designations, or priority claims, key deadline, before 30 months from the earliest priority date.
We talked about where to send the notice IB, receiving office, sometimes IPEA. And the effects withdrawing all designations kills the application. Withdrawing priority claims can reset future deadlines, but not past ones.
And the formalities are huge. Needs a signed notice. We really dug into who needs to sign all applicants usually. Unless you have a properly appointed agent or common representative, a default common rep can't sign for others.
Plus, the strict timing to beat publication prep, the limits once national processing starts, the helpful optional Form 372, and the fact there's no fee.
And finally, the notification chain, who the IB tells, like the receiving office, the applicant, affected designated offices, and sometimes the ISA, with that special case for early withdrawals filed at the receiving office.
It's clear that this flexibility comes with a big dose of required precision. Timing, signatures, knowing who to notify, get any of it wrong, and the withdrawal might not work as intended.
Definitely. Which leads to maybe a final thought for you listening. Consider how detailed and strict these procedural requirements are, even for something conceptually simple like withdrawing. You need the notice there. Before a specific internal process happens at WIPO, you need exactly the right signatures based on representation status.
It really speaks to the need for predictability and trust in these complex international systems, doesn't it?
It does. So think about it. Where else, maybe in business or other legal areas, could benefit from having such clearly defined, even if strict, off-ramps or adjustment procedures? How does this level of formality, this rigor, actually enable the system to function even when plans change drastically? It's that balance between allowing flexibility and maintaining order.
Something to ponder. And on that note, a huge thank you, as always, goes to Mike Shepard. He's the creative director behind this entire MPP educational audio series. His work makes these deep dives possible.
And we must include our disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and Notebook LM. While we've aimed for accuracy based on the source material for this deep dive, there could be errors or omissions. It's for general educational and informational purposes only.
Absolutely. It is not legal advice, nor is it a substitute for formal instruction. For authoritative guidance, please always consult the official MPEP document, speak with a qualified instructor, or engage a registered patent practitioner.
Thanks for joining us for this exploration of MPP Section 1859.
We look forward to diving into the next section with you soon.